Good afternoon, friends. Today I'm going to speak to you about Article 19 of the Indian Constitution. This particular provision ensures fundamental rights are all pervasive through the day-to-day activities that the citizens of India undertake. I say this because it includes the freedom of speech and expression. It also includes the freedom to assemble peacefully and without arms, the freedom to form associations or unions, and the right to freely move around in the territory of India, to reside and settle in any part of the territory of India, and to practice any profession or to carry on any occupation, trade, or business. Therefore, this particular provision is all pervasive because though it is in the Constitution, there are a lot of legislations which stem out of the freedoms that are guaranteed under Article 19(1), be it with respect to formulation of trade unions, Industrial Disputes Act, and the right to assemble peacefully, and the right to ensure that there are political protests, as well as the right to ensure that there are protests with respect to the right to be heard is recognized through Article 19(1), so to speak. And at the same time, it is important to understand that when a fundamental right is guaranteed by the Constitution, for every citizen of the country, it is mandatory to ensure that such a fundamental right does not impinge upon the right of another individual. And therefore, what we see is Article 19(1) is followed by 19, subclause 2, which has defined various forms of reasonable restrictions that are guaranteed in the Constitution to ensure that one's way of life does not impinge upon another's. We have various aspects of freedom of speech and expression, and we see a plethora of judicial decisions that have now culled out through the judicial review various forms of what includes freedom of speech and expression. Firstly, this is the right to information, the freedom of the press to report and disseminate information, the right to privacy, as can be witnessed in the Puttaswamy judgment, the Navdeep Singh Johar judgment, and the Aadhaar card judgment as well. The right to hoist the national flag, the right to demonstration, and also the right not to speak. These particular rights are of great importance because we see its application also when it comes to the laws of election, as can be recently observed with respect to the provision regarding nota being applicable to all elections. As I had said earlier, Article 19 has laid the foundations of a democratic rule in India. However, these rights are not absolute. And there are various ways, and we have some judicial decisions also that have seen how reasonable restrictions have been imposed when it comes to exercising one's freedom of speech and expression. Also, what constitutes criticism and what constitutes a derogatory remark. And judicial review has played an important role in determining when one's right of freedom of speech and expression has impinged upon the sovereignty of the nation or it has impinged upon the national security aspects of the nation. Some particular provisions for which one's right can be curtailed are sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, in relation to contempt of court, defamation, and incitement to an offense. I'm going to substantiate this particular slide with a few examples. When one describes friendly relations with foreign states, one refers to diplomatic ties, and in time, and it would be variable, be it trade ties or be it strategic ties, and especially with neighboring countries. There is a duty on the citizen to ensure that their view, be it in the form of speech, be it in the form of written speech through social media, it should be in a balanced manner such that it does not seek to threaten the sovereignty of the nation as well as threaten the bilateral relations between various countries. Decency or morality has been discussed in a very famous case of D. Udeshi versus State of Maharashtra. In this particular case, the petitioner was prosecuted for the offense of obscenity under Section 292 of the Indian Penal Code, and his conviction was upheld because he possessed the book Lady Chatterley's lover, and he was selling the same. With respect to contempt of court, a very interesting and nuanced approach has been adopted by the Honorable Supreme Court of India in the case of In Re Arundhati Ray. While relying on some American jurisprudence, it has been held that when we speak about contempt of court, the provision is not to be seen as a privilege for the judges, but it is a safeguard for the work that is being done as a member of the judiciary. Incitement to an offense, which these include certain provisions of the Indian Penal Code like sedition or incitement of riots or any religious comments which would seek to enrage the masses. Defamation is of two types, civil and criminal defamation. Whenever one person disseminates information in a public space regarding another person, and if that particular information is not backed by truth, then such form of communication would be liable for defamatory proceedings. When it comes to freedom of speech and expression, we have some very important judgments over a period of time which have expanded the scope of what constitutes expression. One such case is Government of India versus Cricket Association of Bengal, wherein it was held that the Cricket Association of Bengal had the right to ask for broadcasting rights, and they were well within their spirit to seek permission from the Ministry of Information and Broadcasting while deciding as to which broadcaster will be broadcasting the match. Though it was held that Cricket Association of Bengal per se was not participating in the event, the sports event. However, though it was not a case of their expression, this was a case where Cricket Association of Bengal was still allowed to disseminate information because the scope of Article 19(1)(a) is not restricted to only expression but also for dissemination of acquired information. We have some other important cases like the Bennett-Coleman case and the versus Union of India and the Indian Express case versus Union of India, which has led to the freedom of speech and expression when it comes to the rights of the press, and whether it is only the individuals who are entitled to this protection or even corporates are allowed this protection. In the time of the emergency, we see that a particular order was challenged by Bennett Coleman, and it was challenged successfully on the grounds that freedom of speech and expression also includes the freedom of press and the right for dissemination of information. And similarly, in the case of Indian Express newspapers, it was held that a particular provision with respect to the customs tariff that was imposed would be subject to scrutiny, and fundamental rights also extend to corporations, that is, publication houses using newsprint. Birinder versus State of Punjab and Sakal Papers versus Union of India are of particular importance because it is on the basis of Sakal Papers versus Union of India that the Bennett-Coleman case was decided. And it has been held that there is no separate guarantee of freedom of press, and the same is included within Article 19(1)(a). And this is of importance because in a democratic country like India, it is the press that also plays the role of ensuring checks and balance and is often the voice of the people. And therefore, it has the right for ensuring public dissemination of information, access to the essentials that are required for dissemination of such information. Romesh Thapar versus State of Madras is an important case with respect to the idea of propagating ideas freely and circulation of publication. Because publication without having far-reaching outlet to people at large has no meaning. And it must be kept in mind that these were precedents which were established at a time when print media was the only source of media available to the public at large. With this, I would like to now move to right to information. Freedom of speech and expression is one part of Article 19(1)(a). However, the right to seek information is also another form of checks and balances that are imposed. And over a period of time, though we have certain enactments like the Official Secret Act 1923, which ensures that when it comes to state secrets, there are measures imposed not to disseminate all forms of information. However, we have the Right to Information Act also, which was recently amended, but it continues to ensure that public at large has access to statutory bodies, non-governmental organizations receiving substantial government financing, and any other body being substantially financed by the government. Therefore, everything that constitutes state within Article 12 would be a subject matter of jurisdiction under RTI Act of 2005. There are some other aspects of freedom of speech and apart from freedom of speech and expression, like the right to practice trade and the right to move about freely. The right to practice trade and have there are other aspects of Article 19 which include the right to practice trade and occupation. The same shall be discussed in my subsequent lecture, along with some precedents and recent cases. Thank you.